Hey guys, this is Mo from Mo in the Deep End, and we have got some things to go over about the Richard Allen case, and things are popping. So we have Richard Allen files brief with Indiana Supreme Court claiming judge abused power by striking motions from the record. Again, there are a lot of hinky things that are going on with this case. The Chief Justice of the Supreme Court responded to Allen's request in a rush order, saying the petition for relief was verified and any briefs opposing issuance or supplemental records must be filed with the clerk of the Supreme Court before Thursday, November 9th. Once the brief is complete, the court will take the matter under advisement, the order read. Indianapolis, the suspect of the high-profile 2017 Delphi murders case, has filed a brief with the Indiana Supreme Court alleging the trial court has, quote, failed to perform clear, absolute, and imperative duty imposed by Indiana court rules and regulations. Richard Allen filed the realtor's brief in support of a petition for writs of mandamus and prohibition Monday. So let's look up what a writ of prohibition. All right. So a writ of prohibition is a judicial order that must be used at a higher court's discretion to prevent a lower court from interfering with a higher court's determination of a court case pending appeal. So basically, hey, higher court, this lower court is shenaniganizing. Stop it now. Now let's see what was the other one? Because I can't remember nothing. Oh, for the love of all that is Cheetos. And then we want mandamus. All these fun words I'm learning. I will be a lawyer by the end of this. An alternative writ is an order that requires respondents to take action, mandamus, and cease action prohibition. So basically, they are asking this court to take action and to cease action. So basically, asking the higher court to take action against the lower court and stop the lower court from doing the shenanigans. I hope that made sense for you guys. I try to learn new stuff all the time, as my youngest would say. Claiming so these 2 things are going to stop, and this is what they're claiming that the lower court is doing. Hundreds of documents were improperly properly excluded from public access. This case has been insanely so there's been a lot of, lack of public access. In fact, the document dump from May, a lot of that were media outlets trying to get access that they would normally have in a case like this. That was all denied. A Franks memorandum was removed without notice or hearing. The court attempted to remove Allen's counsel over his objection. This is a big one. In our country, we have the right to choose your defense team. I mean, honestly, this is one of the basic rights we have to counsel and to choose our counsel. Mr. Allen has grown comfortable, developed a rapport. They have a strategy. They have, all the defense, all the discovery that they've gotten. You know, this man, Richard Allen, feels comfortable with his chosen counsel. They want to be they want to remove him, and has been no, public disqualification. There haven't been any motions, any formal removal motions for these lawyers. They were simply, kind of like hand of God, Thanos snapped by Judge Gull, and that's not procedural. That's not correct. The court has instructed any filings from Allen's, quote, chosen counsel be removed from public record. Allen claimed that the case involved one of the most high profile matters in Indiana history. He cited an emergency motion filed April 5th to mark documents in the trial as public, which would give access to the media and general population following the case. Allen said on June 8th, when a member of the media requested access to the excluded records, the court ruled that all of the documents had been excluded from public access to comply with a gag order filed on December 2nd, 2022. Attorneys argued that the order only governed, quote, "extrajudicial comments, not court filings." Leaks of evidence. Previous reports showcased some major developments in the case before October 19th, the hearing where Judge Fran Gull explained with cameras in the courtroom. And again, according to Attorney Rossi, and that will be the next video that I do, uh, his his filings are quite damning, and I will go through them with you. Again, this is only Attorney Rossi's, telling of the events, so we don't have Judge Gold's telling of the events. Um, Now me being me, I tend to believe Attorney Rossi, but I will leave you guys to decide. Everyone has their own opinions. I'm not here to make up your mind for you. I'm here to give you, well, not unbiased, but, give you the information and look, I definitely have a slant. I will not lie to you, but I will try to give you guys the information, and you can definitely make up your own minds. Both Allen's attorneys, Andrew Baldwin and Brad Rossi, had withdrawn from the case in an unexpected turn of events. Now, that was both of them only gave oral promises. Now, the way the law works is not with oral promises. If you tell a judge in a civil case that you have an oral promise from someone that you're going to get a bajillion dollars, unless that crap is in writing, that's not going to work. So, this was following reported leaks of evidence by the defense team that prompted the move. Allen claimed he heard in early October that someone had surreptitiously and without authorization photographed crime scene evidence in the case that was stored in Baldwin's office. And Baldwin and Rossi had come up with a plan to prevent further leaks and had detailed that in their petition to stay on as Mr. Allen's lawyers. Both Rossi and Baldwin then immediately informed Allen of the theft, and Allen responded to the court that he wanted both attorneys to remain on the case. Again, their client wanted these attorneys. He has built a rapport. He wants them on. They have gone through the defense. They are doing their job. They are doing it well, in his opinion, and he wants them. He stated in a letter to the court that their Rossi and Baldwin representation to date has been in his best interest. After the hearing on October 19th, the defense filed a motion requesting Judge Gold recuse herself from the case after suddenly backpedaling on a previous story of his impending withdrawal from the case. Now, again, I will go over this in my next video, but they basically had a Sophie's choice. They basically had the sword of Damocles upon their head. Either you orally withdraw right now, which is not a thing, apparently. I asked my friend, apparently that is not the thing. Uh, or you get publicly humiliated and I will excoriate you and take you off this case in live TV. And I find it uh, absolutely petty and ridiculous that the only time that this judge has ever allowed cameras in this courtroom was when she was going to publicly humiliate lawyers for something that really was not. Again, did did they leave stuff out? Yes. Did they accept that a friend was th would you think that a friend and a fellow lawyer, someone with legal, you know, background would do such a thing, would take a sensitive case, would, take photos, crime scene photos, sensitive photos of 2 young girls and use them for profit and, spread them on the internet like some gross smear merchant ghoul of a person, you know, for anyone, for that family to see, for gross people to try to make, clout on? No. No one would think that because normal people don't do that. People with law experience don't do that. Here we go. Judge Gold then issued an order that stated Rossi had withdrawn from the case, again orally, not with any paperwork, not with any proper motions, from the case on October 19th and was no longer the legal counsel of record for Richard Allen. The clerk was then ordered to remove Rossi's filing, calling for the removal of Judge Gull from the records. Official noted it was filed in error since Rossi was no longer legally part of the case. In Monday's filing by Allen, he stated the removal of the filings by prior attorneys is another reason for the brief with the Supreme Court to provide oversight to the trial court, basically telling the trial court to slow your roll. You're getting a little too big for your britches. You need to calm the hell down. Sit your britches down. I don't know what this court is thinking. They are not God. This is not Soviet Union. You can't just throw people's attorneys out without, having disqualification hearing, without doing certain things. This is not communist Russia. Sorry. Allen stated he didn't want both Allen or Baldwin and Rossi to withdraw from the case. There were no circumstances under the Indiana rules of professional conduct to warrant their withdrawal. New defense team. In Friday's order, Judge Gold appointed two new attorneys to represent Allen, Robert Scremen, and William Labrato. And wouldn't you know, they're from Allen County. Now, this probably wouldn't be a problem if she hadn't been so unilaterally um biased at this point. Uh, Judge Gold is from Allen County. In order to avoid the optics of looking like she was favoring her county, there is a method by which you can go to a state pool of public defenders. And it looks maybe a little bit more fair optically because she has looked heavy-handed and uh, I mean, it has sparked a Supreme Court case. What Hershey has done has sparked a Supreme Court case. If that tells you anything, most cases do not. This so these two lawyers are from Allen County. Now, the buzz on Twitter was that she should probably not do this for optics, but she did anyways. According to our news partners, WAN 15 Librato or Libreo is the chief public defender in Allen County. In 2022, WAN reported that Librato was suspended for 2 or 3 weeks in February for an unknown reason. Now, the scuttlebutt allegedly in Pac Man, Tetris, and other things is that there were substances allegedly. He was later reinstated under the condition that he refrained from any retaliation. So obviously, there is something rotten in Denmark there. According to Scremen's website, the Fort Wayne-based lawyer has 24 years of experience in criminal defense law. His listed experiences include work as a former deputy prosecutor and SWAT's narcotic detective. The court has denied requests from the media to film the next hearing on October 31st. That's because the judge wasn't going to lay into anyone and didn't get her, 30 minutes of fame being a giant swamp hag. This is my editorial and my thoughts. You are perfectly free to make your own thoughts. I am editorializing. These are my opinions, and good Lord knows everyone has their own opinions, so feel free to make your own. The court said this was due to unauthorized filming and broadcasting of pretrial activities. Oh, you mean the trial activities where you got into your quarters and basically shark, you know, offered the lawyers a choice between public shaming or seppuku. So let's go to another article. We have from Fox 13. I like to get different articles just to see what things are put in. New attorneys for Richard Allen ask Indiana Supreme Court to decide on access to court documents in Delphi murder case. New civil attorneys for Delphi murder suspects are asking the Supreme Court to weigh in on public access to court filings in the case. There's another problem, I didn't go into it, with the other defense attorney. The other defense attorney, not the one that got suspended for unknown reasons, but when Richard Allen was first arrested, he went on television to opine about the ballistics evidence being fairly damning. Now, he was not representing Mr. Allen at the time, but he is on public record sort of corroborating the state's theory of this tool mark evidence. Again, directly contradicting the defense's theory that tool mark evidence and our lovely friend Nicholas, that tool mark evidence is basically BS or not as not as one-to-one identifying as it has been portrayed in the past. So you have 2 lawyers that have no rapport with this man, a man who has asked to keep his old lawyers, and a judge that has not followed any procedural, steps to take these lawyers off of the case and has acted basically like Genghis Khan, just throwing out the rule books and giving these lawyers, the old heave ho without any procedural backing. New civil attorneys for Delphi murder suspect Richard Allen are asking the Indiana Supreme Court to weigh in on public access to court filings in the case. We know what Allen is accused of. Among civil attorney claims, hundreds of documents were inappropriately excluded from public access. Allen has asked his chosen counsel to make filings on his behalf, and the judge has ordered the clerk of court to remove those filings after ruling Allen's chosen counsel are no longer on the case. Now, there is a workaround, and I've talked to my appellate lawyer friend. While the court can appoint whoever they want from the pool, and whatever pool they want, as public defender, private attorneys cannot be picked. If, say, Mr. Rossi and Mr. Baldwin were to step forward as private counsel for Mr. Allen, now, I don't know how he would fund that. I don't know if they would go pro bono, but if they were to step forward and do that, it would be fairly it would be unheard of for the court to deny that. If this judge denies that, it would be immediately ruled or moved to the Supreme Court. That is patently ridiculous, according to, my appellate attorney friend, believe me. As I said, I'm not a legalologist, okay? I'm just giving you the news. The trial court has failed to perform, quote, "clear, absolute, and imperative duty imposed by the Access to Court Records Rule and trial rules." The Chief Justice issued a November deadline for any party to file objection or supplemental material. The court will then take the matter under advisement. The civil attorneys claim when the court made 118 documents accessible to the public on June 28th, 2013, that's the document that I was referring to. The documents were not labeled in a way for the public to understand what they were, and the link to find the documents was in a court order that required a member of the public to find, read, and understand the contents of the order. It was a bit of a slog to get through it and understand what was going on, I will say that. The attorneys also claim a filing by Allen's defense team raising concerns about the search and warrant for Allen's home was filed as a public document but removed from the record. In that filing, the defense team claimed the probable cause affidavit used to obtain the search warrant for Allen's home misled the court. So she removed the Franks hearing. Civil attorneys also addressed the issue that led to Allen's criminal defense attorneys being taken off the case. In the filing to the Indiana Supreme Court, Allen's attorneys claim he was made aware that a friend and former employee of the attorney, Andrew Baldwin, had photographed crime scene evidence in Baldwin's office and released it without consent. Again, what kind of ghoulish, horrible person takes crime scene photos of little girls and sells them for profit? I'm sorry, I know this person has unalived themselves, and I feel terrible for the family because I know how a sudden unaliving hurts the family, but that is behavior beyond the pale to me. I'm sorry, that is just awful behavior. Selling it for profit or clout, and the people that use that put it on the internet for the family to find is just grotesque to me. I'm sorry, that is a line that I will never cross, that I will never, ever I don't care if I were given the option to be as big as Mr. Beast, but I had to do something like that. I would rather, uh, n quit YouTube than do that. That's just, I can't imagine the family, how that must feel. Okay, rant over, sorry. Sorry, sorry, sorry. A letter from Allen's attorney, Bradley Rossi, informed the judge to the theft on October 6th. The judge Goal responded in part by saying, "Thank you for passing on this troubling information." So she was, not she I don't know if at this point she was laying the groundwork for her public seppuku of these guys or what, but these gentlemen took the time to tell the judge what happened. Prosecutor Nicholas McClelland, or I like to call him Miami Vice, then emails the judge and Allen's attorney that the incident was being investigated by the state police and several people were identified, the first being the friend and former employee who had photographed the evidence and others who had disseminated it. One of those was allegedly involved would take their own life. The judge then responded to the news saying, "I am deeply concerned that Mr. Allen's defense has been compromised by these recent events and a hearing for October 19th." Before the hearing, the filing includes that an October letter purportedly from Allen to the judge in which he claims he was made aware of the theft and still wanted to keep Baldwin and Bradley Rossi as his attorneys. This man wants to keep the attorneys he has. Why is that so hard? However, at the hearing on October 19th, the judge said she accepted Baldwin's verbal withdrawal from the case that day and she expected Rossi to file a written withdrawal the next few days. His attorneys later claimed that Judge Francis Gall forced their withdrawal, and I will read his filings because they're damning, okay? According to a later court filing from Rossi, the defense and prosecutor met with Judge Gull prior to the October 19th hearing when the judge read a prepared statement to Rossi and Baldwin identifying various issues throughout the case of the defense exercising gross negligence, in her words, in carrying out their responsibilities for Allen. In his filing, Rossi sends the judge then gave Rossi and Baldwin two options, quote, voluntarily withdraw their appearances and exit the courthouse in advance of the hearing, or two, participate in the 2 p.m. hearing and the judge would read the prepared statement into the record, then disqualify both Rossi and Baldwin in the presence of Allen, his family, and the public. According to the filing, the defense spoke with Allen, who allegedly reaffirmed he wanted to continue being represented by Rossi and Baldwin. And Allen still objects to the judge taking Baldwin and Rossi off the case. In the court filing, Rossi said the judge had, quote, engaged in an ambush of defense counsel entirely void of due process. Rossi said he agreed to withdraw his appearance, but said he was coerced and did not do it voluntarily. Yes, it's terrible, you guys. That will be my next video. An order by Gull was entered into the record October 19th after the hearing in which she ordered Rossi and Baldwin withdrawn from the case. Then she ordered the clerk to remove them as attorney of record in the case. Subsequent filings by Rossi were then ordered removed from the court record by the judge. Rossi also requested Judge Gull remove herself from the case. The attorney is asking for her recusal, claiming she has shown her impartiality might be reasonably questioned. Rossi goes on to claim that Gull violated the Indiana Supreme Court's administrative rules by removing or concealing some of the defense's pleadings from the case summary. This woman took stuff off of the summary of the case that the defense filed. Where are we living? Communist Russia? I don't understand it. What is going on here? So it, it's just it's ridiculous. So again, right now, what we have is an emergency order with a deadline for November 9th for all parties to respond to the Supreme Court. Now, the latest thing is that uh, we have a hearing tomorrow that will not be covered by any news. It's it's kind of strange, but Judge Gull doesn't want any media uh, in this hearing because it seems like she's not gonna, Sharyukin 2 defense attorneys, so she doesn't want any media there. Isn't that interesting? Now, what also is interesting is that 2 of the motions in the Supreme Court case have suddenly become confidential. Now, according to my appellate attorney friend, that is very unusual. What is going on in this case? What will we learn tomorrow? Will we learn anything of substance? Will these families, will this town get the justice that they deserve from the court system that seems to have gone mad? I don't know. I will be back with my next video going over, Bradley Rossi's filings that were basically yeeted from the court record, prompting this Supreme parts of this Supreme Court, uh, filing, and we will go from there. I don't know. This case has just gone, as I said, mad. I I'm trying to stay positive, but guys, this is quite odd. I do like that, it's definitely going to the Supreme Court. I like that action is happening, but the public defenders that have been picked, we have one that's publicly opined about ballistics evidence that the past defense team has been trying to withdraw because ballistic evidence, as we know, is not as infallible as we were led to believe earlier in, judicial history. And then we have another who's faced disciplinary action in the last couple years. It and they are from Allen County, the county that the judge is from. This judge seems to wield an inordinate amount of power in her courtroom and seems to think that rules are not applying to her. I'm sorry. I don't like this judge. Again, I encourage you to go to different sources, to see the other side, and to make up your own opinions. I am not in the business of telling you how to think, but I definitely am beginning to think something is rotten in Denmark. So that is my video for right now. I hope you enjoyed it. It's a big one, and I will see you later for Newsy News. And I will be back with Mr. Rossi's, yeeted filings. They are pretty rough. So I will see you in just a little bit. Have a wonderful rest of the day. Say something nice to yourself and something nice to someone else. And you know what? Newsy News is at 7. Bye, guys.